Okay, now let's bring in legal expert from Dubazana Attorneys, Nthabiseng Dubazana. If you may have heard the terms of this plea that will be the main focus at the start of the trial, Nthabiseng, next week, Wednesday, the 26th of May. And of course, what we heard in court earlier today, it's based on the Section 106 of the Criminal Procedures Act. Now, if you look at that act, it provides a number of reasons for pleas, or a number of possible pleas, including being guilty or not guilty. We've heard now, as Thulasizwe, my colleague, was saying that the former president is said to plead not guilty, and then he'll have another plea, and that plea is related to the suitability or not of the prosecutor, or having a title or not to prosecute. What does this mean?
So what it basically means is that, remember, there was at some stage a request that the prosecutor recuse himself. So in this situation, they're going to apply Section 106, subsection 1H, whereby they're saying that he doesn't have a title. So when you don't have a title to prosecute, it could be one, you don't have locus standi, which is jurisdiction to adjudicate the matter, or he had retired as a prosecutor, therefore he hasn't been granted permission to practice again, or to go back into court, or that he is not a prosecutor at all in order for him to proceed with this matter. So that is basically what would be the basis of the Section 106 1H application. And
now, in this case, sorry, Nthabiseng, to cut in this particular case with Billy Downer, we've known they've expressed that in previously they don't think he should be there for various reasons. What should we expect? What would be their substantive or substantiation of this particular clause of Section 106, that's 1H, that the prosecutor has no title to prosecute? What can we expect?
We can expect them, all the reasons that they've raised in the past will probably be in the paperwork that's going to be submitted to the NPA. And of course, any other new reasons that would have arisen as a result of the new attorneys being on record. So we're expecting things like he is not given proper authority by the NPA to prosecute. We are looking at things like he doesn't have locus standi. We are looking at things such as bias. We're looking at things, those kinds of lists that we already know exist. So those are the things we're looking at. We're looking to see in the papers that are coming. But for me, what the criminal court, remember, criminal court, unlike civil court, is a creature of the CPA, the Criminal Procedure Act. So everything has to be in accordance with the CPA. So if the argument by the defense attorney does not conform or align itself with the CPA, even with using case law, then that application may just be thrown out of court, right? But if the application aligns itself with the CPA, then we are looking at a possibility whereby the court now really has no choice but to look at what the Act says and then apply that. But then now we're also looking at the state and their response to that application. What are they going to say? How are they going to attack whatever allegations are going to be brought forth by the defense attorneys once the paperwork arrives to them, of course?
Should we expect that plea matter to be dealt with quickly? Because Billy Downer earlier was saying that he has not received the papers from the defense in terms of this particular plea. And also he understands they're substantive, that the papers are substantive. They include an affidavit. Therefore, there's an oath that has been taken, but he still has not seen that. So they need to study that first and then respond. Should we expect that response to happen in court or ahead of court? And how long does it take then to make a call or not on that plea?
Look, when we look at the history of all of the Dubazana matters, the papers that are filed are over 100 pages. So we are looking at with the 26th, when it arrives, most likely the prosecution would not have had time to go through all that paperwork and respond accordingly.
Unless the papers are given before the 26th, in the next few days.
So we are hoping between today and the 26th that the exchange of papers is already done between both parties, and then a response is given, and then that paperwork will then be submitted to the presiding officer prior or on the 26th, and then on the 26th, the presiding officer then makes judgment based on papers that he would have read prior to the date. So I'm hoping there was an agreement in chambers whereby it is agreed that by this date the defense would have submitted their paperwork, by this date the state would have submitted their paperwork, and by this date, the presiding officer will have both, and then have time to go through the paperwork and then make a decision. So on the 26th, we are dealing only with a decision and not any verbal presentation of both papers on both sides, just dealing with the judgment based on whatever papers would have been filed. But because it's such a public case, I've got a suspicion that they would want to read out their own documents in court and then read out the reply and then the judgment be given. But at least if papers are submitted prior, then the presiding officer already knows what his judgment would be. It would be prepared. It would be ready. It will just be a matter of going through the procedure on the 26th.
Okay, and it's very clear from what I saw, and I heard Judge Kuhn saying he wants the trial to start on the 26th. The first matter is this plea. One would expect, therefore, that everybody will be ready. I mean, Jacob Zuma's lawyer saying in court he's always been ready to go to trial. He's ready now. This has taken a long time. Prosecution, of course, they've been ready for quite some time as well. So maybe things might happen differently. But as you correctly said, matters involving whom you called Ntate Zuma in the past have tended to follow what they call his Stalingrad tactics, where there's another delay, there's another delay. We don't know. We just going to have to wait and see, I guess.
Yes, that is very true. And also remember the presiding officer also said that there's also going to be, they're going to entertain the issue of a plea. Besides the 106H situation, they're also going to be dealing with whether or not the accused persons are going to plead guilty or not guilty. So that affidavit that they're going to include in that, I suspect that it's going to be whereby we're dealing with Section 115, which is the not guilty plea in terms of the Criminal Procedure Act, and then also give reasons as to why, which is basically a plea explanation, why we're pleading not.
Nthabiseng, finally, just your thoughts. Can the presiding officer, can the judge find a way, or is there a tool available in law for him to make sure that there's no more delay, especially around the special plea? Or will that depend on how the prosecution will respond to the papers regarding that Section 106(1)H?
You're correct. It will depend on the response on the state, how they're going to reply, and if there is any flaws in their reply, then it will be a matter of there's no choice. The matter has to be postponed until there's a different prosecutor appointed. But if the paperwork on both sides, or on the state side, is intact and everything is fine, then there will be no need for the matter to be postponed. Section 342A would be the one to be dealt with for the matter being unnecessarily prolonged. That's the section that is in the Criminal Procedure Act for matters to not be taking longer than they're supposed to. But hopefully we're not going to get there. We'll just cross our fingers and see how it goes.
Yeah, I mean, it's 20 years on, as we heard, and Patricia de Lille, who's supposed to be the first witness, saying waiting another week doesn't really bother her much. We'll have to wait and see if this trial will actually start on the 26th of May. Thank you very much, Nthabiseng Dubazana there from Dubazana Attorneys and Associates.